Hi, welcome to the channel. I'm Dean Vera, and today in this video we'll talk about why the impeachment trial of Vice President Sara Duterte must start and continue. Welcome back. Again, I'm Dean Vera, and I've already made several videos about the impeachment trial, and I'll give a link in the description below on the series of this video explaining the procedure and any questions that I have previously. Okay, so let's begin. As a primer, as we all know, just to refresh your memory, that the impeachment of Vice President Sara Duterte, the articles of impeachment, were submitted to the Senate from the House last February, 3 days before they went into recess. Now, the Senate themselves said, okay, let's take a break and let's meet again on June 4 or the second or the first week of June. So they themselves caused the stoppage of work. Let's call it a delay. And then as we know in the latest news in the first week of June, they said there's no more time to have the trial. We have a legal maxim in jurisprudence that technically it's sort of you can't have your cake and eat it too. So you cannot benefit from the delay that you caused. But that's beside the point. That's going to be a topic for another video. In this video, we'll explain why I will give constitutional parameters, constitutional provisions that are akin or support the idea that the impeachment trial should start and continue even unto the 20th Congress. Okay? The main point, the bulk of the arguments against is the phrase, as you can see, forthwith proceed. It says this: if there was a verified complaint or resolution of impeachment filed by at least 1/3 of the House, which is already given and cannot be disputed, the same shall constitute the articles of impeachment. And when submitted to the Senate, the trial by the Senate shall forthwith proceed. There are many arguments on what forthwith will mean, but let's put that aside and let's just go for my points, my constitutional provisions why the impeachment trial must begin. Okay, it's already given that when the senators, 24 of them or 23 in this 19th Congress, constitute themselves as a impeachment court, they are technically not senators, they are judges in an impeachment court. So technically it's a separate body, albeit legislative or elected legislative representatives, being the senators. All right? Now, we're talking about time limits because everybody's saying there's no more time, there's no more time. Well, does the Constitution provide time limits for certain parts of the certain bodies of the Constitution? Well, under the impeachment rule, there is a time limit. Okay, it says here under Article 11, Section 3, Paragraph 5, no impeachment proceedings shall be initiated against the same official, let's say Vice President Sara Duterte, more than once within a period of 1 year, which means there's already a time limit that she can only be impeached once a year. So there is technically a time limit given to the filing of impeachment complaints once a year. That is a given fixed time limit. Now, to establish that there are certain bodies in even the legislative arm, both the Senate and the House, there are already several bodies that are constituted that have members of either the Senate or the House part of that tribunal. We have under Article 6, Section 17, the Senate and the House of Representatives shall each have an electoral tribunal, which shall be the sole judge of all contests relating to election returns, qualification of their members. So again, there is a tribunal, the Senate and the House constitute a body, the electoral tribunal, as judge for election disputes. So again, there's another body aside from the impeachment court, and of course already established in other videos, the Commission on Appointments. It is a separate body, albeit the members are part of the Senate and House of Representatives. Okay, so there's a separate body within the same body. The Commission on Appointments, again, it's already been established that it's a separate, and we've already established that under the jurisprudence, Pimentel case, that it's being a non-legislative function, it will not be limited by the bounds of 20th Congress or 19th Congress. It goes beyond that, all right? here, under the Constitution, under Article 6, Section 18, the Commission on Appointments shall act on all appointments. They will act on all appointments submitted to it within 30 days. That means they have to act on an appointment by the President within 30 days from submission. See? So that means they have to give a decision whether they approve or deny or disapprove the commission by the President for his cabinet secretaries or promotions. They must vote or act within 30 days. There is a time limit on that. Commission appointments have a time limit. So, we have commission appointments, and then we now have the electoral tribunals. Electoral tribunals under Article 6, Section 19 says, the electoral tribunals and commission appointments shall be constituted within after the Senate and the House 30 days. Meaning, upon presumption of office, they have the Senate and the House have to create a commission on appointments and electoral tribunal within 30 days upon their convening. So there's a time limit on when they must be formed. Again, the Constitution provides that time limit. Deadlines, if you will. Now, there's another legislative deadline, and every law student knows, taking up Constitutional 1, and I'm sure also political science students knows this. It's Article 6, Section 27 on laws that the President does not sign. It says that the President shall communicate his veto of any bill to the House where it originated 30 days after receipt thereof. Otherwise, if he doesn't act on it, it shall become a law as if he signed it. So meaning the President, by the Constitution, has a deadline to sign a bill into law or act on it. Sign or veto. If you don't sign or veto within 30 days upon receipt, it becomes automatically a law. Meaning the 30-day time limit creates a law even without anything or anybody doing something about it. Okay, so there's a 30-day deadline for a bill to become a law if the President does not veto or sign it. That is constitutional. So we have the legislative deadlines. We have the presidential deadline into having bills becoming into law. We also have deadlines for the judiciary. Okay, it says in the Constitution under Article 8, Section 15, and here it is, all cases filed after effectivity of this Constitution 1987 must be decided or resolved within 24 months from date of submission to the Supreme Court. So the Supreme Court, by rule of the Constitution, has to decide within 24 months when a case is filed with the Supreme Court. And unless it's reduced by the Supreme Court, 12 months for all collegiate lower courts. These are the Court of Appeals, Court of Tax Appeals, Sandigan Bayan. And 3 months from all other lower courts, a regional trial court or the MTC or Metropolitan Trial Court. So the Constitution already provides that the judiciary, the courts must decide in a case or resolve it within a certain deadline, 24 months, 12 months, and 3 months. So there is deadlines. The Constitution provides deadlines to decide on a case. So we already established that there are deadlines for certain bodies. The Commission on Appointments, electoral tribunals, and even the judiciary and the President all have deadlines. Now, I'll give you another point of argument that the impeachment court, although composed of the senators, is a separate body within the legislature. And it's already established that the Commission on Appointments is already a separate, albeit legislative, body. Under Article 6, Section 19, the Commission on Appointments shall meet only while Congress is in session at the call of its chairman or majority of all members. So by the language of that constitutional provision, the Commission on Appointments is a separate body from Congress because they shall meet only when Congress is in session. So it already establishes that the Commission on Appointments is a separate body from the congressmen and the senators as legislators. Okay, we have established that constitutional distinction. One more point why the Senate as an impeachment court shall, if constituted or if created under the 19th Congress, which ends on June 30, can it continue to the 20th Congress? Well, there is a continuity provision in the Constitution, not on the legislative bodies, but on an act or inaction by the Congress, and it has to do with the budget. Okay, we have to establish first that the budget has to be passed by the Congress, both the House and the Senate. And the budget determines how much the government will spend for its operations. Okay, it's to establish that money spent by the government has to have an enabling act through the budget appropriation, or what they call the Appropriations Act. Now, we have a provision in the Constitution that says, under Article 6 in the legislative chapter, Section 25, that if by the end of any fiscal year the Congress shall fail to pass the budget or general appropriations bill for the ensuing, the next year, the general appropriations law for the preceding fiscal year shall be deemed reenacted and it shall remain in force. So meaning, for example, this is 2025. If the Congress does not pass the budget for 2026 on January 1, technically you cannot spend money without an enabling law. The Constitution provides, okay, let's just use the budget limits, the money limits set by the 2025. So for the 2026 budget, if there's no law passed in time, we will use the money appropriations or the money limits established in the 2025 appropriations bill. So again, there is a provision in the Constitution that provides, allows continuity. So, on the argument of others and some of the senators, impeachment court, if constituted in the 19th Congress, can act on its own, separate, and can continue into the 20th Congress because the Constitution allows it. Furthermore, under the impeachment rules of the Constitution, not the impeachment rules of the Senate, there are no time limits. There are no deadlines, except that the only imposition of time is that the trial shall forthwith proceed. Hi, please do me a favor and smash that like button. It'll help me a lot and it will trigger the YouTube algorithm. Now, if you have not yet, please subscribe to my channel. If you don't, my dog will eat this exam booklet and that student has to repeat his final exam again.